pleasant welcome to another edition of the program Familiarise with the Law, coming to you from Star Television, Channel 20, when we broadcast live from our Media One Center, 3 Mama Street, Brookfields in Freetown. My name is Abdul Rahman Kamara. My guest in the studio is lawyer Sonkita Conte, Director Namati. Welcome to the program.
Thank you so much, Abdul Rahman.
And viewers, you will have the opportunity to actually catch up with us if you are in the capital city of Bo and also Makeni, channel 36 and channel 41 respectively. In today's edition of the program, we're going to look at land management, intimidation of landowners, complex process in land acquisition, compensation including corporate social responsibility, so many things. You will agree with me that a couple of years, Namati Organization of Dialogue have held a dialogue forum on the role of paramount chiefs in land management, land degradation, the central control that borders around intimidation, and also the legal representation, all of these. But the crisis seems to be pretty much unabated. Issues surrounding land has been pretty much frequent. You go to the courts, there are instances of land litigation on lands. What is pretty much central that all of these problems don't seem to subside?
So the challenge we have, Rahman, is the fact that our land administration system is archaic. These are systems that were set up during colonial times. And unfortunately, over the years, we have not moved with the improvements in society. We've not moved with the changes, the complex changes in society. And so we're still struggling to use colonial era institutions to address problems that are 21st century. So take Freetown, for example. In Freetown, we have the formal legal system that allows individual ownership of land. And so if I have a piece of land and I want to sell it, I would need to do a conveyance and then have that document registered. Now, unfortunately, the system we have allows me, if I want to be dishonest, to sell that same piece of land to 5, 6, 7, 8, 9, 10 different people. And there is nowhere in the current system where the red flag would go up to say that, there is a problem here. This gentleman, well, he wouldn't be gentle with you selling land multiple times.
Supposedly.
Yes, this man is selling the same piece of land to several unsuspecting buyers.
Because the system is not automated.
Because the system, not only is it not automated, the system in substance allows for the documentation and registration of documents, as opposed to, in other countries, the registration of title. So there is a very important distinction there. And so we have that situation. And if you look at the turnover in land transactions over the years, it's increased significantly because people from outside of the country have worked for years and they want to come back home to invest. People from within have also worked and they want to acquire land so they could build their own small houses. The price of rental houses has increased significantly. Landlords are asking for 2 years rent in advance, and sometimes they ask for rent in US dollars. So most people think that it's a wise investment to secure your own piece of property, and that has resulted in this massive influx of rogue elements into the land market, and the system really has not helped.
I was just about to put forward a question to you as to whether this could be seen as a rather convenient excuse, especially so for multinational corporations to seize such an opportunity, going it the way they like, in a rather chaotic manner as we have it.
So absolutely, the fact that we don't have any sober system in place that really allows for the proper administration of land is a factor in these new developments on land issues, which is the large taking of land by companies for either large-scale agriculture or for mining purposes. Now, for those who have been following, there is a clear distinction between how land is dealt with in Freetown and how land is dealt with upcountry. So in the rural areas upcountry, land is governed by customary rules, and these rules are not documented. Similarly, the rights that people have in land in the provinces are also not documented. So you would find it very difficult to see a family that owns land in the provinces that has a document to show that this land was acquired for our fathers or forefathers or in any particular way. So the fact that you don't have a system of title registration, of securing of rights in the provinces that would allow people to show documents or proof of title means that people's rights are not significantly protected. And so you have a situation where, for the first time in some communities, it's when a company comes in that you have some sort of a documentation of the land itself. So the company would go and take 50,000 hectares of land, and then would get a surveyor to go and survey the land for the first time, produce a plan, and from which they would then develop a lease agreement which either the chiefdom council or the families would sign in favor of the company for sometimes 50 years or sometimes less.
I was just, before we come to look at a very critical element in all of these, especially so the contractual principle to freedom of contract in land lease agreements, rather ask how important could that be. Do you, in your view, believe that land management system requires an effective and publicly accessible land information management?
Absolutely.
Are we late? Are we late in getting to that point?
So there's this saying, it's better later than never.
Or given the shambolic arrangement over that bedeviled the whole land arrangement over the years?
Absolutely, and I think it would be foolhardy if we say, because of the current problems we're facing, then let's not do anything at all. I think there is still time.
It's worsening of the situation.
Exactly, there is still time for us to do something about this system of land administration. So for one, you have a plethora, you have a number of institutions that have business with some aspects of land administration. So you have the Ministry of Lands, for example, the Department of Surveys that countersigns and endorses plans that are produced by licensed surveyors, and then you have the Office of the Registrar General that keeps charge of conveyances that are developed by lawyers, or even lease agreements that are developed by lawyers for land in different parts of the country. In the past, there was little or no communication between these two institutions, but because of the high incidences of fraud, they began to put in place some sort of scheme by which plans that are signed by the director of surveys would somehow be sent through a slightly formal channel to the Office of the Registrar General, so that when you send conveyances in, they compare those plans in the conveyance with those that they have received through the Ministry of Lands. Now, that's a good first step, but quite frankly, it's simply not enough. We need to address the whole spectrum of land acquisition. So from the surveying to the determining of who actually owns the land, which is something you cannot fully guarantee, even as a lawyer. So someone's name could be on a conveyance, but it's impossible for you to say with determination that that person whose name is on the conveyance is the owner of the land, because there may be like 6 other conveyances that exist prior to that conveyance, and so it really is a difficult landscape to maneuver through. So I would say that in spite of the hugeness of the problem, it's quite significant. The challenges are massive. We still have an opportunity to try and resolve this problem. And I think that is why it's useful to always point to the fact that the previous government managed to set out a land policy. Now, this land policy is ambitious. It sets out a blueprint for the reform of the land system in the country. It provides, for example, for the switch from a system of registration of document to a system of registration of title. It now would allow for land across the whole country, not just in Freetown, to be mapped and documented, and for those lands to be registered as well. So we do have the framework there to help improve the system. And what we need to do in the coming years is to actually implement that framework, which is a land policy, okay, to ensure that we improve the system.
I was going through an op-ed you did some years back that borders around the Adax Bioenergy sugarcane ethanol project in Makeni. From a legal and human rights audit report. The indication is that in January 2009, a local newspaper reported the launch of a multi-billion-dollar bioenergy known as ADAX. This news was received pretty much pleasantly by the administration then. But the implication that's occurred immediately after this project was launched was based on perhaps what many people may refer to as a fundamentally flawed process that borders around the contractual principle of freedom to contract in land lease agreement. First off, before we come to look at the nitty-gritty of all of this, how important is this principle in a contractual agreement?
So it is very significant.
Freedom to contract.
Absolutely, it's very significant. Now, it's based on the assertion that if this thing belongs to me, this land or this car or this item belongs to me, I should have the freedom to enter into an agreement to dispose of it, to even give it away, on terms that I deem reasonable. So I should be able to do that. I should not be either coerced, I should not be threatened to agree to certain terms. No one else should use some third-party influence or undue influence on me to influence, the outcome of any arrangement. And so that is a principle that is geared in everyone's right to own a piece of property. And within the context of Sierra Leone, land in the western area it could be owned by individuals, could be owned by corporate entities. Now, if those entities decide to dispose of any interest in land, they should have the freedom without fearing that some other powerful actor or entity will determine how they contract. They should be able to contract very freely. Similarly, land in the provinces, in rural areas, is owned largely by families and to a limited extent by communities. Now, the same principle applies to those kinds of ownership. That in that circumstance, if a company is going to contract with a set of families or a community to secure land from them for business purposes, those communities, those families should be able freely to enter into negotiation with the company or companies in question without having to look behind their back if the government is coming, or without the government attempting to influence the processes. Now, in the context of land in the rural areas and in the context of large-scale investment in land, we see that principle being eroded, principally by the government attempting to establish some artificial value of the land that is held by families and communities in the rural areas. And so, around 2009, the Ministry of Agriculture issued some what they called policies. But essentially what that document did was to stipulate an artificial rental value for land in rural areas. And that rental value is what is about $5 per acre. And so what that means is any company that is going into large-scale agricultural activities in the provinces that wish to secure a lease from the people there can only pay up to $5 per acre.
On the element of consideration, rent, and compensation, the argument often put forward by ADAX, they claim that government has no role in the lease process other than making sure that the law and procedures are complied with.
So, I mean, definitely government's role has to be one of a referee to ensure that no side takes advantage of the other, that the rules are followed. But in this particular case, the government is going beyond being a referee. By setting the terms of a lease agreement, you're going beyond being a referee. And so if you insist
on the prior informed consent of the holders,
so there is no consent there. When government says land up country that is acquired for agricultural purposes should attract rental value of $5, there is no consent. The government is using its coercive power to impose on communities in rural areas. Now, companies could negotiate and get land for $2 per acre. That is fine, as long as there is nothing that compels communities to accept a particular amount. So there has to be that freedom.
Son Kisa, I may sound redundant in asking this question. Forgive me if I do. How much do you understand that traditional land owners, and chiefdom council have had access to effective legal advice in preparation of a land lease?
So that is a major issue as well in large-scale land acquisition. And now, normally what happens is a company comes in ready to acquire assets and do business. They have access to huge resources. They can pay for lawyers both within Sierra Leone and outside Sierra Leone, and that was the case for ADAX as well. These lawyers will prepare lease agreements and other documents that would favor their client, the company. But unfortunately, on the other side, they're dealing with communities who do not have access to legal representation. And so what has been the case, and this is something we've seen all across the areas we operate, we've seen companies and their lawyers drawing up the agreements and taking the agreement to communities and telling them, listen, the rent is ready. Look at the agreement. If you put your thumbprint on this one, you can get your money, without necessarily allowing communities to say, we would like to influence the content of this document. We would like to have our views represented in that document. And so that has been a major challenge in the whole process of land acquisition. Sometimes some companies would say, we want to do the right thing, so what we will do is we'll get a lawyer for the community. But then there's a saying, he who pays the piper calls the tune. So if the company is paying the lawyer directly to provide services for a community, I don't see how that lawyer would be dedicated to his or her job. Definitely they would be influenced by the company.
In a situation where there is a kind of dispute on the contract that the landowner entered with the company, then on a pro bono basis, you go in defense of the community, the landowners. Does this require the presence of the company lawyer to actually come to the fore and put on a defense?
So one of the things we do as an organization, as Namati, is to provide this type of legal backstopping to communities, either when they negotiate these kinds of agreements with potential investors or even after the fact. So we've been involved in situations where the community has signed an agreement that is not in their interest, that is completely one-sided. And so we go in and we tell the companies, this agreement is unfair. The community was not represented. So we are requesting and or demanding that we reopen the agreement and have fresh negotiations. So we've had situations where
in your view, apologies, in your view, which of the intervention do you believe ought to have been solid? Access before the fact?
But of course, it makes sense, and for us, it makes our job really easier if we're there at the time the agreement is being negotiated. So being there at the start helps us, because the whole process of helping to negotiate an agreement is quite involving. So you would need to have lots of meetings with communities. You would need to get their views. You would need to examine environmental impact assessment reports. You would also need to examine international standards of best practices. So there are many things that are involved in this. So it does make sense to be included at the very beginning, and that is what we're pushing for. And I'm glad to report that the land policy is also trying to make that achievable by setting out that going forward, companies that want to invest should be paying some amount of money into a community justice fund, and that fund would be used to secure independent legal services for these communities to represent them at the negotiating table, so that when the companies come with their lawyers, the communities can also show up with their lawyers and or paralegals, as the case may be. So absolutely, it makes our work very easy if at the start we are involved.
That has not been the practice.
No, so it's not been the practice at all. So it's been a company having access to lawyers and then drawing up agreements and sending it to the community for them to thumbprint, or in other cases, the company saying, we will get a lawyer for the community and we will pay the lawyer directly to provide services to the community, in which case you know what happens in that situation.
So on the question of when dispute arises, referral of dispute, I preview a situation where we are quoted to have said the list is to be governed by the laws of Sierra Leone, but the clause 5 suggests that the dispute may be resolved by arbitration outside Sierra Leone. The clause eliminates any right of appeal against arbitration decision. This one is hard.
And the reason for that is simply because communities did not have access to legal representation and assistance at the start. So if they had an independent lawyer at the start who would have looked at that first draft,
all of this should have jumped
yes.
over.
So for example, you're coming to Sierra Leone, you're going to Bombali to acquire land, and then you're saying that if we have disputes concerning the land at Bombali, instead of resolving it in Freetown or in Bombali or in Sierra Leone, let's go to the UK to go and resolve it. Now, how do you expect the community, authorities or the landowners to fly to the UK and resolve disputes that you have with respect to a subject matter that is in their community in Sierra Leone. So this is evidence of the fact that when communities are not represented from the beginning, you tend to find these very terrible clauses in these kinds of agreements.
In your view, do you think the current environment within the land management system is pretty much conducive that could lure investors into the country against the backdrop of the huge beneficiation of our local natives?
So, I mean, there are two ways you could answer that. The first is that there are investors who are looking for these kinds of situations.
Rogue system.
They're looking for countries that have very poor regulatory mechanisms, very old laws that they could take advantage of, very weak capacity within their regulators, and so they come in, and then they basically have their way. So when you look at some of the investment agreements that Parliament has ratified over the years, they are mostly drawn up by lawyers for the investor who's coming in. And one of the patterns we saw in some of those investments is that when it came to the obligations of the government, those agreements are so exact, so specific, that there is no ambiguity at all. Like, government must provide us with